Welcome to Legal Straight Talk. I'm Brett Harrison from the Harrison Law Group. Thank you for tuning in. Today again, for another part on drunk driving, we have Thomas Lavalle. He's a former DA in Suffolk County and now criminal defense attorney, so we get the good inside scoop. Thank you again for coming back.
Brett, thanks for having me again. I appreciate it.
We didn't quite get to everything because I guess we got heated up about different things. And
We were talking too much. We're lawyers.
That's what we do, you know. But so last we left off, we were talking, now you're in the precinct because there was reasonable cause to believe when the police officer pulled you off on the road and found that there was an indicia that you were drinking and it impaired your driving. So now you're back in the precinct and they say, listen, you got to take the breathalyzer. Now comes the moment of truth to the individual there. Do I A, call my lawyer, which I believe...
That's a good idea.
Do we call it? Because you do have a right, am I correct?
You do, but they don't have to wait for the lawyer to call back.
Well, how long do they have to wait?
That's reasonable time.
Well,
They have to give them the opportunity to speak to an attorney, but you can't just let it drag out and drag out. But that's a great first
because that
avenue.
stalls you to let you think, am I correct?
True.
And to speak to, hopefully you know a lawyer, you're not just dialing, help me, or something.
I hope they know a lawyer.
Most people have, they know who to call to find out who's been in that situation. They don't like to admit that they've been there, but
let's assume now you can't get a hold of that attorney. So now you got to make that decision.
But how long do they have from, let's say you're arrested at 1 a.m., how long do they have to give you that breathalyzer?
Oh, okay. Well, New York has a rule. It's supposed to be 2 hours from the time of arrest. However,
What's the time of arrest when they
at
stop
the side
you?
of the road, when you're placed in handcuffs.
So if they stop you at 1, but you're not placed handcuffed till 1:30, then it's 1:30?
Correct.
Or
But
is that a game that can be played?
really can't be played too much because this is what happens. Let's say you said 1:30 is the arrest. The rule is you're supposed to give that test to the defendant within 2 hours. However, case law says if they ask you after 2 hours and you take it, it's still admissible. But if they asked you after 2 hours and you refused, it couldn't be used against you. So it's a little, even though the law says 2 hours, the interpretation is not that way.
So now you're sitting there, and do you take the test?
Well, as we started to talk about it,
Oh, well, but before that, I'm sorry. You get a hold of your lawyer,
okay.
shockingly at 2 in the morning, and they're not stalling. Can you answer their questions without them listening in? Obviously, the lawyer's going to say...
When
you know,
I've had those calls, I would say a couple things. I speak to the client. I said, "Is the officer in front of you?"
Okay, give
Yes.
it to me. I'll be the client arrested.
Right. So is the officer in front of you?
Yeah, there's 2 of them.
Okay. So I'm going to ask you questions. Just say yes or no. Were you drinking?
Yes.
Did you have beer?
No.
Did you have shots?
Here and there, a couple.
I'll just go through those kind of questions. Yes, no, how many, and then I'll try to figure out how many that person had within a certain period of time. So without the officer having to hear, I could say, was it 1 shot, 2 shots, 3 shots, 1 glass?
Now, while I'm being arrested and being transported to the precinct,
Right.
aren't they going to be asking me questions?
They could be.
Well,
Normally they don't, but normally they don't. They usually wait till they get to the precinct.
But they're going to ask me questions because the more I admit, the easier it is. Whatever I say can be used against me,
And will be.
whether I'm not telling the truth or not. Can I just say, you know what, I'd rather not talk to you? Or
Yes.
or am I going to look like I'm guilty? That's what a lot of people feel. If I don't say something, you know.
Well, this is what I always tell clients. You're locked up. No matter what you say to the police officer, you're not going home. So why would you talk to the police officer? So the police officer maybe he misheard you. Maybe, you know what I'm saying? If
So
you're
you're-
under arrest,
So
Don't talk.
it's almost like better to be thought stupid than known stupid. Is that what basically you're saying? You're saying basically,
I never heard it that way.
but you're saying basically better to be thought drunk than known to be drunk by your own admission.
Absolutely. Yeah, you're arrested. You think the officer's going to unarrest you because you told him, officer, I only had 2 drinks or 3 drinks? Not happening. So
The fact that you're already down there, you're not free to leave.
exactly. You're going to either take that test or not take that test.
And you don't have much time to think about it.
Well, not usually, because the officer would generally want you to take that test sooner than later, right? Because they're afraid that, the level could be going down over time. So now you have to make that decision. If you can't get a hold of your attorney, you're going to take that test or refuse that test.
So your advice on that, well, how much did you drink? Now, this is all predicated that this is your first DWI. And we'll get into the importance of that as you were talking about it before. Because you may have different advice if somebody's on probation, parole, or if it's their second DWI.
Yes, but it's still going to be that general rule that I like to use. If you know you've had a substantial amount to drink and there's no way you're passing that test, why are you taking that? Because you're just going to blow some high number, which is going to make it more difficult to try to resolve that case later on.
Because now it's quote-unquote scientific evidence as opposed to human error.
Lawyers believe it's more difficult to win a case where there's a reading, that jurors believe the machine. I've had some cases that the jurors have thrown the machine out, but that's the general rule.
And it's just people always say, can you mess around with the machine, pretend you're like blowing? Can you explain that to them?
Well, supposedly the machine has safeguards. It's supposed to have a volume kind of detector, whether or not you're breathing into the machine, how long you're breathing into the machine, and if you don't breathe in long enough, the machine will say insufficient sample, those kind of things.
Okay,
so you can't do that kind of try to puff up your cheeks and try not to blow into it. It's just not going to work.
So now let's say you say, you know what, I'm not taking this test. What happens then?
Well, the officer's going to say, I want you to write refuse, and then if you refuse the test, this is where the catch-22 always is. You haven't taken the test at the precinct, so now the police officer does not have a reading that can be used against you at trial, which is generally good. However, for purposes while the case is pending, you may not have a license, because what happens is when you have a refusal, you actually have two actions that are going on. You have your criminal action for the driving while intoxicated. Then DMV gives you what's known as a refusal hearing.
Are you privileged to drive in any capacity?
Right. So what happens is you go to court, you get arraigned by the judge on the DWI with no reading. You didn't blow into it. The judge says, well, because you didn't blow into it, I'm taking your license away. And within so many days, you're going to have a hearing over at DMV. And when you go to that hearing, I have to say, most of the time, if the officer shows up, you'll lose.
It's a kangaroo court.
Yeah, it's an administrative court. Yes, I'll leave it that way.
But you as an attorney can use that to your advantage? Can you question the officer?
Yes, if the officer comes, I can question him, use it as discovery. But the big point I wanted to get out was, you lose that refusal hearing, you're not eligible for a license until the criminal case has been resolved. Because you're not eligible for a conditional license.
What does that mean? Explain to people what conditional means. That means the case isn't over, am I correct, when you have a conditional initially?
Right. Well, I'm going to try to explain it this way. Let's say you did take the test, right? There is a suspension for your license. If you blew an 08 or more, the judge is going to suspend your license.
Does the judge, he or she, have the discretion whether to suspend you?
No, it's mandatory. But you're entitled to to a conditional license while the case is pending. So in the situation where you go to the precinct, you blow into the machine, you blow over an 08, at arraignment, judge takes your license away, but you can get what's called a hardship and a conditional while the case is pending. With that refusal, you can't. You go to DMV, you lose. You cannot get a conditional license until your criminal case is resolved.
Well,
and that could be 6 months, a year.
When you get arrested, how quick will the refusal hearing be, the initial?
The refusal hearing is within 15 days.
Can you stall it? Are you entitled to?
No, you can't stall. If you go to the refusal hearing, you say, Judge, I'm not ready, I just got retained.
Right.
They'll say, that's fine, Mr. Lavalle, you can have a date, but in the interim, I'm going to revoke your client's license. You can or I should say suspend it. I'm going to suspend it and we'll adjourn it. So that's done no benefit for your client.
What if the cop doesn't show? Police officer.
Then the judge more than likely will adjourn the case and not take action on your license.
And how long will that adjournment be?
Generally 2 to 3 months. You'll get notified by DMV. So yes, as a lawyer, when I go there, if the officer's not there, that's kind of good, because my client can get his license back. The case at the at DMV will be adjourned for a couple of months, and that gives me time to resolve the person's criminal case. Because you always want to, on a refusal, you want to try to resolve the criminal case first, because once you resolve that criminal
You don't have to
case,
deal with the
you
refusal.
can get a conditional license for that refusal.
You don't have to deal with the refusal part.
Well, you still have to deal
but
with
not
it.
the DMV part.
You still have to deal with it, but you can get a conditional license because you got all these different suspensions. For refusing to test by DMV, and I'm trying to keep it simple and move it along, it's a
Right.
1-year revocation of your license. But if once you resolve that criminal case, you can get into the drink and driver program, you can get a conditional license, so you can have it for that 1-year period. So that's why you're always trying to resolve that criminal case. And there's other little things lawyers do. If you lose the refusal hearing, you appeal it. You try to get a stay. Sometimes that
How hard
might...
is that to do?
That's not that hard, but that takes some time. You know, you got to file it with DMV, and then
So
it
now,
could take...
now let's add up, just so people understand. Now let's really look at the cost, okay?
Yeah.
Okay, so now what we're talking about is, let's say it's your first DWI,
Right.
no fatality, because then it's a whole different ballgame, different conversation.
Yep.
Now you have to pay for an attorney. Now, attorneys can, and let's assume not including trial. Because
Okay.
attorneys generally, I found, will do one fee
Up until trial.
up until trial, because it's a total different ballgame once you go to trial. What would you say on average? Give me a general range that you find, all different varying experiences, for non-fatality, just your...
Driving while intoxicated. I'm going to say the low end, 2,500, you know,
And would you say the high end, 75?
75, could be 10.
Okay, so you'd say somewhere probably around 5 to 7.
Exactly.
That's just for the criminal, not including trial.
That's right.
And now if it's trial, it's usually equivalent, or if not more?
It's going to be more. Well, I should say, if you're starting at it's going to be 5, 6, 7, 8, something like that for a trial.
Now you also, if there's a refusal, there's another fee, correct?
Some lawyers do it, yes.
Because that's that's not criminal, then now we're
True.
dealing with the civil, right?
Right.
Now you're also, let's assume there's a conviction, you also have effects on your driver's license for, what is that called? I think they call it assigned risk.
Correct. For insurance purposes, you're going to be in assigned risk, and I
think it's 5 to,
I think it's 5 years, too.
7 years. And let's say your insurance was $2,000, your insurance now will probably be closer to 6 to 8.
It's going to be high. I don't know the numbers. but
Ridiculous.
Absolutely.
Now, on top of that, so now we just started to add all the costs.
I'll give you more.
Okay.
Fines at the court.
Okay, on a basic DWI, what's the fine?
The minimum fine is going to be 500 with either 255 or 395 surcharge, depending if you pled to an impaired or intox. Then you're going to have a DMV driver assessment penalty for 3 years. That's $250 for each year for 3 years, so that's $750. If you refuse to take the test, that's a $500 civil penalty from DMV. So you're going to
All right, now you also have you talked about the machine in your car.
If you are unfortunate and you have to plead to the misdemeanor, you're going to have a criminal record, you're going to have ignition interlock in the car, generally for a year. Some judges do it
How
for...
much is that?
I've heard it's like, could be close to 100 a month, then you got to pay for it to be installed. It might be like 80 to 100 a month. So it all adds up.
And that's only part of it. Now, let's say you were put on probation. There's a fee for that too, isn't there?
That's true, and then you got to go for alcohol counseling, you got to pay for that
Now, it
fee.
depends, and they decide alcohol counseling based upon your ability to pay. Am I correct?
Yes, they have like sliding scales, but you don't want me to get into that.
No,
that area.
but I'm saying, so these are just, and this has nothing to do
Like
with
a rich guy
jail.
like you'd be going for counseling for a long time
Or you.
because you got money.
Wow. In theory.
Well, you're a civil lawyer. You got tons of money. You do personal injury, so.
But so you just went through a whole bunch of fees that has nothing to do with jail. Now, on top of possibly, if you're a bus driver, okay, let's say you work for
forget it,
DOT,
yeah.
and I'm not saying you did it commercially or anything, but you have a commercial license and you were caught, like you said before, with your car, you probably lost your job.
You lost your job, that's for sure.
And I think automatically, if you work with certain unions and certain jobs, as soon as you're arrested, it automatically gets reported.
Well, that's more like some of the state agencies, like maybe like nursing and
Police officers.
right. Once you're fingerprinted for your job, you get notified. So the penalties are
And now you say, how am I
Extreme.
going to pay for, assuming you don't have a trust fund, how am I going to pay for the house? How am I going to pay for the kids to go to school? And this is all over a drink, or two, or three, or four.
Right. Let's just say it's a bad choice.
Bad choice. But the other effects of it I look at is when you're counseling people, you have to know, am I right, that you discuss their economics. You discuss what they do for a job. Who's the breadwinner in the family?
Yeah, I discuss what does my client need to move forward with his or her life, right? What are you looking for out of this case?
And sometimes it's not about justice, it's about the economics. And I hate to be so pointed about that, but that's, justice could take, if you want to go to trial, it's not happening in 5 months, am I correct? It's not happening in 2 months.
No, it's going to be more like 9 months, a year, maybe.
That's if you're in Nassau or Suffolk. Let's say you're in Queens or Manhattan or the Bronx, Brooklyn. It could. It's not uncommon. It's not uncommon that it could take more than a year.
You know what I wanted to talk about also was, I don't know if now with the new DMV regulations, if you have 3 or more alcohol-related offenses within a 25-year period of time, you'll lose your license for 5 years on top of any penalty. And then after 5 years, you're eligible for a conditional license for 5 years with ignition interlock. So I've had cases where I have
where's
a guy.
the person even going to get insurance?
I've had situations, family man, he's married now. When he was a young guy, had 2 DWIs. Now it's his 3rd one. And, if he takes a plea to a driving while intoxicated, he's not going to have a license for 5 years. And then once after that 5 years, like I said, these are new DMV regulations within like the last year or two.
What I find interesting is
There's
that,
lifetime ones.
let's say you're charged with an intox, a low reading. Let's say you're charged DWI 0.10, okay, 0.09.
Okay.
And, you're told after a month or two, I can get you an impaired. I'll have you back on the road. I'll get you a conditional, I'll get you a conditional license so you really, at least that you can go to and from work, you can maintain, and you're not going to lose your job. And I say to you, but you know what? It's just unfair. I really don't believe I was drunk, but you know what? You tell me the alternative is if you get convicted, and this may take 6 months, 9 months, I can't tell you you might not
you got
lose
to weigh
it.
the risks.
And you're going to have a criminal record, am I right?
Exactly.
And now you're going to say, well, let me ask you a question. Are you the sole provider? Are you going to be able to take, you have to go to court.
Listen, I lay it all out. I talk to the client. I give them my recommendation. It's their life. They have to make, they got to make the decision. But generally, I would say that's more like on a refusal where somebody really wasn't even drinking at all. They're not impaired. They're not intoxicated. Maybe they got off wrong with the officer and they didn't take the test. And now at some point, they're offering you the impaired. What do? Even though you know your client's not guilty of anything. But that's, something they got to consider.
Going back to the refusal, you hear this term refusal video. Can you explain that to people? What is a refusal video?
Well, in Suffolk County, there's only a couple of police officers that actually have video cameras in their car, or at least as far as we know. It's generally the highway police in the, what they call Stop DWI department. So not every police vehicle has those cameras. So it's just a select few that have it.
So if you
Maybe
refuse,
like 5 or 6 police vehicles.
They don't do it at the precinct, a refusal?
No, Nassau County does have a setup, but in Suffolk County, no, there's no videos. Because, and I always say this to the juries, that, the officer can paint whatever picture he would like.
Camera wouldn't lie. Camera is perfect. It could be good or bad, I guess.
I always say this, the camera would have, you wouldn't really need
You'd
most
be
of these
there.
trials. It's either you would see and say, it's time to work out a deal, or
Your client could see the reality one way or the other.
Absolutely.
But now, how about in Queens and the 5 boroughs? Do they videotape?
I don't know. I don't practice there. I don't believe so. I haven't heard about that. But I know that, like I was saying, Nassau, when they bring you back to the central booking area, if you do a refusal, they'll videotape you right at the precinct, and you can.
Well, now, at the precinct, do they videotape you doing any other tests?
Yeah, they have them do the walk and turn. They have a line.
Do they have to give you that video?
Yes.
In Nassau and Suffolk?
Well, just well, yeah, you always have to get the video. You're entitled to the video. I mean, it's recording of your client, so
But not every precinct records it, though. Am I correct?
very few. Very
But
few.
wouldn't that stop the insanity? Stop the tie-up in the courts? Hey, look, let's just go to videotape. Why?
I
We
think it
shouldn't be
would.
afraid either way. With
The
your
truth
police,
is the truth.
Exactly. It is what it is. That common saying we always hear.
And I've heard more and more jurors say, we would like to see the video, you know?
Are you
And
allowed-
I had one juror, I always like this, the videos police the police. You know, and I'm not trying to listen. I'm the police. I'm not trying to pick on the police, but, you know, there's all sorts, and some people exaggerate, and it's just human nature. And, you know, the officer believes the person may have been drunk, and maybe they exaggerate. So, you know, a video,
Or that, like you
It's
said
the
before, they got off on the wrong foot with the officer. They started yelling, or they started saying things, and that could affect it.
it can, absolutely.
And that doesn't usually come out too often in the court. 'Cause the officer comes in with a uniform, don't they?
Always.
Can they? I mean, don't you find that as a defense attorney? I find that they shouldn't be able to come in with a uniform. I think because in a civil case,
understand your logic.
in a civil case, there's rules for depositions, and when you're in court, they cannot come in their uniform. Why is that fair? I think it's prejudicial. I mean, I'm playing a little advocate here, but
Well, I kind of agree with you.
you know, you
because-
see that nicely starched uniform. You assume, a lot of people assume, well, you know, they have a badge to tell the truth. They're telling the truth. They're wearing a uniform. I think it's, why should they be able to come in like that?
You're not going to get disagreement from me.
Can you make that argument to a judge? Say, Judge, that's not
I
fair.
could, but I know what the answer would be.
What would the answer be?
It would say, absolutely, why can't he wear it? The
Yeah, if
judge
you
would
say-
say, they would say, why can't he wear it? He was wearing that when he arrested your person and your client, then why can't he come in with you?
Will you question jurors, you know, when you're picking a jury, say, just because they're wearing a, will you
I'll do-
discuss that?
Yeah, I always do that. But then at my closing, I say to the jurors, I say, you know, ladies and gentlemen, we all say how we give the officer the same type of credibility as anybody else. But I said, do we really? I mean, because I said, if we did, you would have a reason to doubt. You know what I mean? Because he's just another person, and we've given you other evidence. You would have a reason. So I try to
You know,
address that
I'm gonna
issue
go a
with the
step
jury.
further. Why isn't the officer held to a higher standard? Now, they're trained, right? They understand the ramifications and consequences of charging someone, denying them their freedom, okay? Why aren't they held to a higher standard? I would actually say the other way.
Well,
Why
as
isn't
you-
that?
Well, there's a specific, because the jury instruction says he's to be given the same credibility
But
as
the
anybody
reality,
else.
credibility, but they're training and they understand consequences.
See, if you tried to argue that, a judge might cut you off. You know.
Well, how could you argue that? Say, well, you know, they're trained. My client's not. Can you say it this way? Do you hold a teacher or a principal at a higher standard than, let's say, a substitute teacher? I mean, that's one way around it. I mean, wouldn't you? I mean, I would say, you know, an officer in my eyes, has a higher standard. I don't know why that's wrong, and I don't know why you can't say it, because I think people think it.
Well, I think you could ask it. This is
In a
my opi-
roundabout way?
I think you can ask the jurors, but I don't know if you could argue that during the trial, is what I'm saying. If you started to argue that higher burden, I think a judge would shut you off and say, you know, he's like any other witness.
But don't the prosecutors sort of say that? They say, you know, he's an officer.
Well, he's got all this experience. He's made 100 arrests.
Let's be honest. He's made 100 arrests. He's got a good record. Because obviously, if the officer had a bad record or something, you're going to try to get that in there if there was incidents previously. Am I right?
Oh, yes.
Okay, so they're saying, in essence, the officer,
He's an expert.
they call him an expert because he was trained with what? A 48-hour course, a 4-day course? Is that? And you're saying it was because he's done 100 arrests. So you're characterizing him different. They're characterizing him that way, aren't they? Essentially.
You're right on point. They always do that. I mean, wouldn't you if you were a prosecutor, right?
But why
My
is that?
officer's
hold
got
on,
so many years' experience.
That's
so
a
many
double
arrests.
standard, isn't it? Because if the prosecutors can say that, and intimate that they're on a higher level, then why can't we say, or not we, but you say, you know what, the prosecutor's right. They have training, they have years. This person's been an officer for 17 years. He can't even count how many DWIs and arrests.
I think you could do all that, but I just don't know if then you could say he has to be held to a higher burden. That's all. I know I'm getting a little technical, maybe a little technical.
No, but it's just
here,
stuff like that bothers me a little bit. I think it's a little unfair, and if anything, it should be swayed to the person that's being charged, the defendant.
There's a lot of things that are unfair, and it gets back to the videos and stuff like that, because as a defense attorney, there's only so much I could do, and that's what I tell the juries, I'm not going to break down the officer.
Again, we're at the end,
Yep.
and we could keep on going. I want to thank Tom for coming in, Lavalle. Tom, what would you, last word of advice for our audience, what would you say?
Last word of advice. If you know you had too much to drink, don't take the test. And don't say anything to the officer after.
I would say leave your car parked, get it towed, and pay the $300 so that you're safe, the community's safe, and also that you get home in one piece and you could still provide for yourself and your family and your career.
That's even better.
That's how I would wrap it up. Also, one last thing. Just if you know someone's drunk and you don't want to drive, don't let them drive, because my understanding is you could also be charged for letting someone else drive your car knowingly that they're drunk. So that doesn't get you out of it as well. But that's another show. Once again, thank you for tuning in to Legal Straight Talk. Thanks again.
Give my regards to Broadway. Remember me to Herald Square.
Hi, I'm Jerry Parisi. Join Tom Neely and Tommy Marr right here on Cablevision Channel 20 each week for an interesting episode of Long Island View.